Thank you to everyone for joining us today, whether you're live as we are broadcasting this simultaneously from our premiere episode, or whether you're joining us on demand over the course of the next several months. We are glad you are here. We value your participation and your time, and we respect that. And we have a panel here to provide some great insights into our topic today, resolving shareholder disputes. We will go for about an hour with our program. It will be a lively dialogue. And first, I have a few administrative housekeeping items to touch on. The slides are there for your review. They are to add and enhance the understanding. They include background materials, which you're welcome to peruse, take notes on electronically or manually. And today we have a couple of sponsors. This program is produced by Financial Poise. We have a variety of Financial Poise programs throughout the year. There's a website, financialpoise.com, where you can find out more information. The program is also co-sponsored and co-produced by the National Law Review, a legal news website with analysis of a wide range of legal and business topics. It was established in 1888. A brief disclaimer: we're here to share live, honest, open insights. We're not here to provide advice regarding any particular matter. You should consult with your own advisors. And in that vein, I'm going to introduce our speakers and also give you our speakers' contact information. So if you do want to reach out to anyone on the panel or reach out to me as the moderator, please feel free to do so with any questions you have. So it's my pleasure to introduce our panel. The bios are in the slide deck with their contact information. We have a panel here with a valuation and forensic accounting consultant and expert, a panel with an arbitrator and mediator who's highly experienced not only as an arbitrator and mediator, but also formerly as a sitting judge, and before that as a litigator. And we also have an attorney who's a very experienced business litigator, but also focuses heavily on shareholder disputes. So we have Megan Beckwire. She's the principal of Dispute Economics based in Philadelphia. We have Janelle Dressen. She's the managing partner of Anthony Oslin Law Firm based in Minneapolis. And we have Judge Thomas Mulroy. Judge Mulroy is with Dispute Resolute Systems here in Chicago, where he does arbitration and mediation. And me, I'm John Levitsky, is the moderator. I do forensic accounting, valuation, and damages analysis cases in a variety of disputes, including in business divorce. Now, you'll see here a little theme. We're talking about business shareholder disputes where the owners can't get along. This can also include other forms of organization, which we'll touch on later in the program. It's not just limited to corporations. Sometimes it's separation, sometimes it's dissolution, sometimes it's some other potential manner of having the shareholder dispute get resolved. And that's really the focus of today's program. There's a variety of series in this array of programs in which our number 3 today, resolving shareholder disputes, occurs. There's also a 4th program on avoiding bankruptcy actions, and there are 2 prior programs on business breakups and lost profits cases. You're welcome to join those as well on demand or the number 4 live, however you choose to do so. They're available on the Financial Poise website. So let's get into our program. And like I said, I'm not going to flip through the slides, but they are here. I'll just show you so that the audience knows that the slides are here, that you can peruse those as you find appropriate. So with that, we're going to start. We're going to talk about like understanding what a dispute is. We'll talk about some of the ways to potentially resolve them. And we'll also talk about one of the key issues is like valuation, money, as part of this evaluation and also as part of the resolution. So Judge Mulroy, would you tell us what exactly is a shareholder dispute?
Thanks, John. Shareholder disputes are exactly like a divorce, and John referred to it as a business divorce in his opening remarks. 2 people, sometimes family members, a brother and a sister, get together. They're thrilled to open up a business, let's say a jewelry store. They say, well, let's do it on a handshake basis. Everything will be fine. They don't provide detailed documents showing what their relationship is. As slide number 1 says, the documents that they do have never provide any kind of a relevant way to resolve disputes that they have. Things start off wonderfully. They have 2 customers the first week, 20 customers the third week, and they're making all kinds of money after 6 months. 3 years later, they start to fight. One person isn't working hard enough. One person's taking too much money. One person's cutting me out of the decision. One person is ordering all the jewelry for the jewelry store and not consulting me, and I don't like her choices. What do you do now? Shareholder disputes are so difficult because not only are they legally difficult, they're so emotional. Of all the cases that we all have handled in our careers, shareholder disputes, really next to matrimonial divorce, I think are the most emotional and the most difficult to resolve. Later in this program, we're going to talk about how they're resolved if the documents that originally formed the company aren't clear enough on what you do. But even if they are clear, there's always a dispute as to the language. But shareholder disputes can arise in major, huge companies. But most often, the ones that we see are in smaller companies. And a lot of times they involve family members.
Well, thank you. Janelle, what are some common reasons? Why do these shareholder disputes occur?
Yeah, and I'll pick up, thanks, John, on what Judge Mulroy said, which is there is a lot of emotion involved in these matters. So, I sometimes you hear, it's about the money, it's about the money. And for many different kinds of lawsuits, that's very true, and money resolves things. That is not necessarily true in shareholder disputes, because the emotion piece, we're trying to solve for emotional pieces that necessarily the legal system can't solve for. And so the lawyers involved, the mediators involved, and sometimes the judges end up getting more in the kind of advisor therapist role than in the legal role. So, which, we're not trained for. So that's what makes it very difficult to solve these matters. But, the different kinds of shareholder disputes, the most, easiest ones, I would say, are that fall into the category of lying, cheating, and stealing, where you have a bad actor involved. The more common, though, that you see, that happens in cases and the parties point fingers, just like you would in a matrimonial divorce, where there's the finger pointing and you did this wrong and you did that wrong, is not, though, necessarily lying, cheating, or stealing. It's more about control. So there might be fighting about, where the business should go in the future, the business strategy. Should we grow? Should we put more money back into the business, or should we pay more money out in shareholder distributions? Should we expand the business? Should we shrink the business? Should we go in a different business line? Should we not? Who's in control of those decisions? How are those decisions made? What information is shared? Bottom line, who has a voice in the management of the company and those decisions? And there's lots of fights that can break out over that. And it varies from differences in risk tolerance to different objectives to different stages of life to spouses getting involved. All sorts of different issues can be impacted, to tax issues, to banking issues, to your audit issues. So there's lots of different things that can start and cause a shareholder dispute. And just know that it's not always just about the money, and most times it's not.
Well, thank you, Janelle. Now, let's talk about money. Let's talk about from a financial perspective, because sometimes that could be either the outcome or it could be the driver sometimes. So Megan, from from a financial perspective, how could you give us some examples of some of the issues that might drive a business divorce dispute that might also affect valuation?
Sure, John. Yeah, thanks. Based on what Janelle just said, we can kind of categorize it into these two broad categories, right? Of the situations where you have the bad actors. So an example of that might be where one shareholder owns the real estate and is causing the company to pay in excess of fair market rent for that real estate. And maybe the business doesn't even need that real estate. Maybe everybody's working from home, but they're still paying this rent. Or they're taking out excess compensation or perquisites, things like that, as the majority shareholder that may be causing the earnings of the company to be deflated. So the company could be losing out on opportunities to get beneficial financing terms. They could be losing opportunities to have new investors if that's an interest. And, ultimately, the value of the company is impacted by that. And the minority shareholder's position is going to be reflective of that detrimental kind of situation that they're in.
Thank you. So, Judge Mulroy, where do you start? Might there be a roadmap or some documents that might help us evaluate? Like, what's the process? So, do documents exist
don't
or
we
maybe
wish?
make a difference?
Don't we wish there were documents that we could? I mean, there are documents that we could prepare, but we don't. We're going into business with our sister. We don't need any documents. That's what we think. 6 years from now, we're fighting over the real estate costs. We're fighting over the purchases that I've made. We're fighting over me taking my children on vacation with company money. There are shareholder agreements that you could find on the internet, actually, but it's better to go to a lawyer who could resolve a lot of problems, can anticipate a lot of disputes, and provide for a way to resolve some of those disputes. As Janelle and Megan pointed out, you can never resolve the emotional part of this thing. And sometimes there are two bad actors, and each thinks the other is worse. And that, of course, makes it even more difficult. So you think you're doing the right thing by taking your children on a vacation to Yellowstone using company funds, and the other side thinks you're just stealing money. And then she's got exactly the same kind of a thing that they charged to the business. A shareholder agreement, which outlines how you can use company funds and who's responsible for what and what the remedies are fabulous and are certainly available and should be used. It's trying to convince the client to use them before the dispute arises and not to look afterwards and come up with a way to fix it. Most of the shareholder disputes in smaller companies arise and there are no documentation. There is no documentation, and they kind of have to try to figure it out on the fly. And of course, that also impacts the valuation of the company that we're talking about. There are ways to calculate the valuation, how much the company is worth, that could be agreed upon at the time they get together and begin the company. It's not often done, but boy, does it prevent a lot of problems in the future.
I'd like to add to that because, and I'm saying this against my own personal financial interests because I resolve shareholder disputes and I'm a litigator and trial attorney. But having documents in place is by far the best advice you can receive when you're forming a business and starting a business, even if you think it's a small business, because it could take off. And it's usually when the business is succeeding and there's money to fight over that you see these disputes. But having documents in place while it doesn't mean you won't have a dispute, the way the dispute progresses and the likelihood that it gets solved quicker is much higher if you have documents, because courts like to enforce agreements between the parties. And so if they can, the courts will do so. If there's no agreements, you can imagine you may be fighting for years. So you have the time factor, the negative impact on your business, and then the legal fees. And I would also highly recommend against pulling any documents off the internet. I think pulling documents off the internet and using them as your agreements is just as bad as not having any documents at all. Because if you're not trained in the law and you don't understand this area, which it is a specialized area, you won't know what you're agreeing to. Then you'll be fighting over that, you didn't know what it meant, and the documents are probably not that great, and they have mistakes in them and or unintended consequences. So you are much better off, and if you're an advisor to a company that's forming, much better off to advise them to spend the money up front. You may spend several $1,000s to get these agreements in place, but if you don't have them, I guarantee you if there's a dispute in the future, you'll spend tens, if not hundreds of thousands of dollars having to fight.
And Megan, is there ever anything in the documents that might provide some insight as to valuation?
Yeah, absolutely. As Judge Mulroy pointed out, the buy-sell agreement can dictate the manner in which the business is to be valued or specific calculations that are to be performed. And sometimes if those become unrealistic later on down the road, they can be questioned. But in a lot of cases, that's a great first place to start. So even starting out with a business valuation, if you've got a shareholder that's buying in to a business and everybody has agreed on the method that's used to value the business at that time, that's a great example of a method that should be applied going forward, because everybody, when they were getting along, has agreed that that was a representative approach.
Well, Janelle, if there's going to be some kind of financial outcome, do your clients get outside professional valuation help? And if so, why would that be useful?
Yeah, I mean, the reality is the way many of these cases are solved, or the only real way that courts can solve them, is there's some sort of financial outcome. And in my experience, the most common outcome is there's going to be a separation of owners that don't get along, right? The courts are not in the business of dissolving companies, especially successful companies that have employees that should stay in the marketplace. So they do what Judge Mulroy indicated earlier, which is it's going to be a corporate divorce, and that's a separation of the parties. And how do you do that? Well, there's going to be an exchange of financial terms. And that generally means there needs to be a valuation of the business. And in my practice, it's one of the first questions I ask my clients when they come in and they have this kind of matter they want to talk about, is what is the value of your business? And have you ever received a professional opinion? And why do I ask that? I ask that because we need to know what we're fighting over. If we don't know what we're fighting over, we shouldn't be fighting. So I tell them what the likely outcome of the matter will be. Of course, it's always unpredictable, but, I think most of these disputes end in the separation. Somebody's going to be buying somebody out, maybe an order of the sale of the company. And in order to consider all those issues, you need to know what the company's worth, which is why I think it's important to have upfront working with a professional valuation advisor to take a look at the information and give an opinion as to what your interest and the company is worth. And the other value of that is having that independent voice, assisting and resolving what, usually again is a complex issue, complex matter.
Well, thank you. Judge Mulroy, a valuation consultant or valuation expert in the dispute resolution process, what kind of role might they play? And is there possibly more than one role or different roles they could play?
So we're going to talk in detail about dispute resolution. There's the taxpayer dispute resolution, which is going to trial, the justice system, which everybody hates. And there's also the alternative to that, which is called alternative dispute resolution, where you pay your own mediator or even arbitrators to decide the dispute. And the valuation experts play a little bit of a different role depending on the dispute resolution procedure that you pick. So what happens in shareholder disputes is, after arguing for months and years, one party finally says, look, we have to end this, buy me out. Or you have a judge who says, this can't be resolved, so we're going to have to sell the company and split the profits. Now you have to value the company, and it's very hard in smaller companies, neighborhood companies, my jewelry store example, to value a company. You need an expert witness, and there are wonderful expert witnesses on valuation who look at your assets and who look at your sales, look at your profits and losses, and look at your, the goodwill, which is so important to some of these companies' value. Each side can get a valuation expert. You could agree on a valuation expert and then abide by his or her determination. There are a variety of ways to value a company. And I wish that valuation was more black and white. Sadly, there's as much arguing over the value of a company, even with experts, as there is without the experts. This whole area is hard. I handled these cases when I was a judge and when I was a lawyer, and I've tried to mediate and arbitrate these disputes, as my fellow panelists have. And they're very difficult because they're really, the parties don't really accept whatever the other side's valuation expert says, or whatever the other side puts value on the company. They don't seem to accept it. So it's kind of a work in progress. Megan and Janelle, do you agree with me on how hard this valuation process is?
Well, I mean, I can't speak for Janelle, but coming from the perspective of actually performing the valuations, it's true. There are really a lot of considerations, and sometimes the information that's available to either side is going to impact which analyses you can run or some of the assumptions that you have to employ. And so I think one of the best ways that, if it's possible to do, to come to some resolution, is to have the experts, if one has been hired by either side, to have the experts come together and make a list essentially of the large aspects of their analyses that cause the value to differ, and then try to get them to come to some more reasonable consensus on those specific assumptions. Because if you can narrow it down to those few issues, and generally there are going to be just a handful, then you can kind of bring things a little bit closer to a center line.
Yeah, that's a great suggestion. And I always find that the person who is working in the shop the most has a dramatically different valuation idea than the person who is a part owner of the shop but isn't, working there 24/7.
So I to respond to that, I mean, I agree. What I always tell my clients is, unfortunately, valuation is not, it's more of an art than a science. So if we have a valuation expert and the other side has a valuation expert, I'm pretty sure I can almost guarantee they're not coming back at the same number. I've never had a situation where they've come back at the same number. Instead, what I've had are the experiences where they're hundreds of thousands, millions. I've had cases where we've been tens of millions of dollars apart. And then we have a situation now where we have to take that to the judge, and the judge has to decide. And, the valuation experts are subject to cross-examination, and they are asked about all of their assumptions. And then the judge, many of whom are not, don't have the training in how to do a business valuation, have to make a decision of which expert are they going to follow, and how are they going to recalculate if they're going to pick something in the middle. It's definitely not an ideal situation. So if there is a path under which you can agree, like Megan has suggested, on assumptions, or even agree on a single valuation, or you have better yet, you have agreements that provide for a path of how you pick a valuation expert, and then everybody's bound by it, even better, so that you aren't in this situation of battle of the experts over valuation.
And wouldn't it be great if you could do that when you were forming the company and not when the dispute arises? And Megan, I agree, by the way, and I hope I didn't suggest that anybody should go on the internet and print out those documents. I think that is a road to disaster.
Yeah.
So Megan, valuation does valuation mean the same thing as of any date and to all people, or when we're talking about a business divorce, especially if we have some documents or a dispute resolution process, are there some key inputs, some key items that would be helpful if it were laid out in those documents regarding valuation?
Well, yeah, definitely. The standard of value is going to be the first one because, a fair market standard of value is something that everybody's pretty familiar with. If we get into the legal system, then we're going to end up with probably a fair value standard. And I can get into that in a little bit, but that's one of the most important things because really you're going to have a different answer. For every purpose for which the valuation is being done, you're going to have a different answer. So if there's an investment value because somebody's interested in purchasing the company, or the company is going to be sold to third parties, then we need to know who they are and when that's going to occur, and a variety of circumstances that are going to impact that value. Now, if it's fair market value, it's hypothetical buyers and sellers, and you still need to know as of which valuation date, but at least then there aren't so many kind of gray areas. As far as the valuation and the terms that can be written into a buy-sell agreement or an operating agreement at the get-go, what really comes into play the most, I would say, is the applicability of discounts. So under fair market value, the shareholder's interest is discounted according to how marketable it is and their relative control over the decisions of the company. Under a fair value standard, that's not necessarily going to be the case. So again, those considerations are really important because if you've got two valuation experts that are using a different standard of value, or even applying a different level of minority or marketability discount, those can make very large swings in the difference between these valuation opinions. So agreeing on as many of those terms as possible at the beginning can really eliminate a lot of the time that has to go into the back and forth.
Megan, I'm sorry to interrupt.
Go ahead.
How do you communicate to a third party or a judge or mediator this kind of technical information and make him or her in a way he or she can understand it, if you know what I'm saying? I mean, when experts come in front of non-experts, they tend to talk in a language that they may assume the listener is following, and the listener really isn't following it. Are there any tricks to that?
Well, I mean, you break it down as simply as you can. And in the valuation report, they become quite lengthy because you're trying to really establish pretty intricate, points as to how you've considered, if it's fair market value, then these are the considerations that went into it. And here's the difference between that. And for example, if you're working in a case of a shareholder suppression action and you're not sure whether certain of the claims are going to be upheld, I like to put in different scenarios then and say, if these claims are upheld and it's determined that there was excess compensation, then you would have this additional amount that can get added back into the cash flow, which has this impact on the value going forward. It's really a matter of just slowing down and and explaining each step of the process and all of the reasoning behind it as best you can.
Are you frustrated, Janelle, when you try to explain this to a judge who has no clue?
I get frustrated, but I also understand, and only frustrated because obviously it's really important to my client that we get it right. But listen, I've been doing this for 25 years, and there's several concepts that still confuse me because it is truly different with every business. And I agree with your assessment, which is trying to get the valuation experts to speak in language that we can understand doesn't always necessarily work. What I like to do is have them create like a 1 or 2 page summary of the key concepts and focus on that, which is usually the differences between the two experts to try to help. But even then, it can be very confusing. And I also think from a judge's perspective, the worst part for the judges is you hear each side, but you don't have any help to figure out what you do if you agree with some assumptions that one expert made and some assumptions that another expert made. How do you get the new analysis putting in those combined assumptions and come up with a number?
And in addition to that, the non-expert, whether it be a judge or a lawyer, says valuation. Well, that's pretty obvious. I mean, isn't that the easiest thing you can do is value a business? And then when the experts come and explain to you how it's the most difficult, it's a whole education process for the audience.
Yeah. Yeah. I've had judges before appoint their own independent appraiser for larger cases to help advise them. And I understand why they might do that, but that's not really a tool I think that you can use in many cases
and it's so expensive too.
That's what I mean. It has to be in the most large cases where that may be the case, and in some courts it's not even permitted for judges to do that.
Right. So, and then they fight over who you're reaching out to.
Of course.
Sorry, John.
Oh,
I got interested.
This is great. I just wanted to follow up on one aspect of this. When prospective owners, prospective shareholders or partners come together and they contribute different amounts of capital, say shareholder A contributes $1 million and shareholder B contributes $3 million. They invest, they capitalize the company with a $4 million upfront equity investment. They all pay the same price per share. Is it possible that they have not at that point anticipated what Megan mentioned, that if the outcome is fair market value as a standard of value, that at exit, the shareholder that invested $1 million might not be getting the same price per share as the effective valuation as the majority shareholder? Is that a possibility, Megan?
Well, sure. Yeah, that would be absolutely the outcome in that scenario. That $1 million shareholder would hold a inferior position, let's say, to the one that invested the $3 million. So it's definitely a consideration if you have people that are coming in and purchasing in equal amounts, that you may want to have more of a method that prescribes notice discounts being applied, because if everybody agrees that they want to maintain their proportionate share of the whole, then you don't want the consideration of discounts to have to reduce that value. So they could be shooting themselves in the foot essentially by electing fair market value as the standard.
Okay, well, thank you. Well, I mentioned at the outset that there are different forms of organization of entities. Corporations are one, but there are many others. And also we've talked amongst ourselves about the different types of parties and relationships that may be involved. So Judge Mulroy, how may the form of organization of the business entity or the relationships amongst the parties make a difference?
Well, it, it makes a difference, but it only gets worse. It never gets better. So if two strangers go into business together and one stranger thinks the other one is stealing from the cash register and making all the decisions, they're no longer friends. If a brother and sister do the same thing, not only are they no longer friends, but they involve their entire family in the dispute, beginning with their parents and going right on down to their siblings and then their next door neighbors. And pretty soon, everybody in a X mile radius is involved in this shareholder dispute. And, they vilify each other. And that's true, really, no matter how you own your business, if you're going to go into business with somebody else. Now, I don't want to be a big depressive here. There are ways, to avoid these problems, and we've talked about them already. Planning ahead, going to a counselor or a lawyer, a business person who has been through this before and can explain to you what's going to happen. People will liken paper preparation before you go into business to asking your fiance for a prenuptial agreement. It's very uncomfortable. Everybody gets nervous. They say, oh, you'll treat me fairly. Everything will go fine. And the lawyer who you consulted has to explain that I'm sure everything will go fine. I'm sure you'll never need this, but this is what we do. This is standard, just in case anything comes up. I mean, the lawyers are in this area. As Janelle said, it is outside their expertise to be a psychologist or a psychiatrist, but you kind of have to do that before folks go into business together. If you can, advise them on how to protect themselves going forward. It's tough. I don't think that there's much of a difference in the level of fighting between two friends who go into a business together and two siblings who go into a business together. There are legion stories of family businesses run by the mom and dad, and then they bring in the sons and daughters, and then they bring in the grandchildren, and the whole thing explodes. So I don't know, John, that was a long way around me trying to convince anyone who's listening that before you go into business, even if it's a little jewelry store in a suburb, you ought to consult a trusted advisor, and you ought to put paperwork together in order to anticipate some of these issues. And I'm going on too long, and you ought to discuss how you value the company. I think really one of the biggest problems is that people don't understand at the beginning that valuation is going to be such an important issue. They say valuation, I contributed $500,000. She contributed $500,000. The business is worth $1 million. Just give me my $500,000 back. And of course, it's much more complicated than that. Sorry, went on too long.
Well, we appreciate your insights. Janelle, what about the legal issues? What are the legal types of claims that underlie what gives rise to a shareholder dispute? Because just because parties don't get along, that alone may not be a legal claim.
Right. So the essence of these claims typically sounds in fiduciary duty principles. So in private companies, in most states, there certainly are exceptions, and this is state-based law. So you need to look to the state in which generally the company has been incorporated or formed. The fiduciary principles that will apply will typically be good faith and fair dealing, honesty, transparency. And so that's kind of the centerpiece of these claims. But there's also other claims, of course, that get brought. There may be, if you do have contracts in place, it may include contract-based claims, breach of contract, such as if there's a buy-sell agreement that was violated, It may be executive employment agreements that might be involved. And the reason I say that is because a lot of times in these private companies, the way owners get a return on their investment is they're also employed by the companies. And so if there's a termination of employment, that can also lead to these kind of disputes. And so that contract may come into play. There may also be claims for fraud. And then many states, not all, but more than half of the states have statutes that come into play here for what may be called shareholder oppression, or unfairly prejudicial conduct. Every state is different, but looking to statutory protections as well, and you may have a statutory claim.
Well, thank you. You mentioned some of the factors, for example, regarding fiduciary duty. Are there some factors regarding fraud? You'd mentioned fraud as well.
Yeah, so fraud, this is where I think this falls in the category of where you do have truly some bad actors. On the one hand, in the one bucket where, if you have somebody stealing from the company, okay, you might have a fraud claim there. But you can also have, in the context of fiduciary principles, and this is what a lot of people don't fully understand, is there are duties under many of the state's laws that do require affirmative disclosure of material facts when you're in this fiduciary relationship. And so if you fail to disclose material facts or you misrepresent material facts to your co-owners, that can also result not only in a breach of fiduciary duty claim, but a fraud claim. And why does that matter? Well, typically when you're bringing a claim sounding in fraud, most states that I'm familiar with would allow for punitive damages to come into play if there's fraud. That may be the case for breach of fiduciary duty too, but certainly when you're at the level of fraud, it also impacts the business, okay? There's something to be said about to your lenders, to your auditors, to your customers, to your employees, when you hear the word fraud, right? When that word comes out, it just brings on a new meaning and a new challenge for the business that's above and beyond fiduciary duty. And so when you get in that realm, that can cause lots of problems and challenges for the business.
And Janelle, it's so common that everyone adds a fraud count in their arbitration complaint or their law division complaint for that exact reason. I think that they a lot of times add it for leverage. And anyway, yeah.
Yeah, because it ups the pressure, if you will. I do think that for lawyers that are advising clients in this arena as to what types of claims to bring, you may just throw that in there without giving it full thought. It is important to seriously consider the negative impact of that type of claim can have on the business, including with taxing authorities, before you just throw it in there. Because once it's out there, particularly if this is a public proceeding and not arbitration, but you're in court, once it's out there on file, it's out there on file, and you can't pull that back in.
And that's absolutely right. And also, the fraud counts take over the case. If you're in court, they take over the case. Everybody focuses on the fraud. Whereas if you left the fraud out, you'd get more, I think, focus on kind of the basic, exclusion of profits and that those kinds of issues, and also maybe even valuation. But the fraud count kind of takes over a lawsuit, which I don't think is always good if you want to get to the correct result. And of course, it raises emotions too, through the roof.
Absolutely. The other thing that it does that I wonder if people don't think about is sometimes in these cases, there's insurance coverage, like there's an officer's insurance, or if there's a defamation claim, it could even be under a homeowner's insurance. Once you allege fraud, that you also create risk with potential insurance coverage. So there's just a lot of potentially unintended consequences when you throw out the word fraud that people, again, I think you need to have somebody experienced advising you to make sure you understand what those consequences could be and you're making a knowledgeable and conscious choice.
And let me just say one more thing, because as a judge, I faced these kinds of civil complaints that are sometimes overwrought. But they also throw in civil conspiracy and the RICO statute. They also try to use in shareholder suits to make matters even worse.
Yeah, and I'll say I've never been successful at that. So I mean, I don't include that in my cases, and I do represent a lot of plaintiffs and defendants, but I've never seen that be successful in these kind of cases, and I personally think it does more damage than good.
I agree.
So, Judge Mulroy and Janelle, just briefly, does it make a difference if one party's a majority control shareholder or not? Like, does that affect their responsibilities? And then also, is there something called oppression? And if so, what is that and how does that factor into shareholder disputes?
Janelle?
So,
yeah. So, let me start with kind of the second question, which I think these are very related. Shareholder oppression is the type of claim that's brought against those in control of the company. Usually, that is also the majority shareholder or shareholders. Sometimes, though, it can be the board of directors that maybe are not majority shareholders, but they're controlling all decisions either as a board or it may be the board and the officers. So many statutes, in order to bring a shareholder oppression claim, it does need to be brought against those who are controlling the company. But that's also true under many common law laws in the states. So, and the reason being is if you are controlling the company and you're doing it in a manner that's what's called oppressive or unfairly prejudicial to the minority, that can set you up for a oppression claim. And what does that mean? Usually it means you have the majority controlling the company in a manner that's to their advantage and to the minority's exclusion. For example, you're trying to squeeze them out of the company by failing to provide them information, not giving them a voice in any part of the management of the company, maybe not paying dividends or distributions, so they're getting no financial return and you're locking up their investment completely. Meanwhile, those in control of the company are paying themselves excessive bonuses or excessive compensation. Those are some of the examples of what an oppression claim might look like by the majority against the minority.
And that's also a breach of fiduciary duty allegation, is it?
Yes. Yeah.
Yeah, and of course, the more the minority shareholder complains and sends emails and writes letters to the majority owner, the more the majority owner fights back by limiting the minority shareholder to access to the books and to the records. And that's really almost always the beginning of these disputes.
Yes, that's right.
Well, thank you. Megan, we've touched on valuation. Are there some common approaches to valuing a business? And if so, how would a valuation professional select among those approaches in a particular situation?
Yeah, well, there are three overall approaches to value. And as business valuators, we're actually held to a standard that we have to consider all three. So normally you're going to find that you have better information to support one or two, and a lot of times that will drive the decision on which to kind of lean more heavily on. But the methods themselves are the income approach, which is based on historical returns in the market. So observations of what investors have required as returns on various types of companies that they are invested in. So you start with the stock market and then you go to small stocks, and then there's adjustments that you can make all the way down to get as similar as you can to the type of business that you're valuing. And then you have to have some estimate of what the future cash flows of that company are going to be. So you might use either kind of historical average to capitalize and say, I'm just going to use one period and turn that into a future value, or you have an actual detailed set of projections that are multi-year, maybe 5 years, and you reduce that all to present value at that rate that the investor is going to require as a return. And that's how you come up with value under the income approach. The market approach, most people are most familiar with because they've sold a house or they've purchased a house, and that is a really common approach that's utilized in real estate as well, where you have comparables. So in our case, it's comparable businesses. It has to be as comparable as we possibly can make it in order to make this a valid comparison. But if you can find, 25 other pizza shops that have sold and you're valuing a pizza shop, then that's probably a pretty strong analysis in this case. But if you have kind of a, specialty design practice or something like that, where there aren't a whole lot of other companies that do that work, it's not going to provide as valuable an input, even if you can find some other businesses that have transacted. And then the asset approach is based on a restatement of all of the assets and liabilities at the relevant standard of value. So it might be fair market value, it might be fair value, but either way, they have to be restated on the balance sheet. And if you've got a company that has any intellectual property value, so goodwill, basically, the asset approach is typically not utilized because those are not carried on the balance sheet at the relevant standard of value. So you would have to value the intangible assets separately using a market or income approach. So it becomes a multi-step process. So the asset approach gets used more for holding companies. And as far as which to select, it's just what you have the best data for. What do you have the best available evidence to support? You want to be able to triangulate by performing all three. So you've got the most well-supported answer you can come up with. But ultimately, it's going to depend on what information you have, what's reliable.
Well, thank you, Megan. So Judge Mulroy and Janelle, Judge Mulroy, what are the classic processes for dispute resolution? And then Janelle, are there some advantages or disadvantages to the ones that are used typically in resolving a dispute? So Judge Mulroy.
So there's several ways you can resolve a dispute. So you're fighting now, your small business is a success. One person accuses you of something, you accuse the other, you start to fight. You don't know what to do. Both of you want more control. Both of you dislike the other person. The first thing you do is you complain to all your friends. And sometimes you take their advice, and that's always wrong. I would not advise that alternative dispute resolution. The first thing you should do, of course, is sit down and talk to your partner or your business partner like you have talked to him or her your whole life, and which is why you're together in this in the first place, whether it's your brother or your sister or your mom and dad. Sit down and talk. Make some notes about what your problems are so that you don't get overly emotional in this conversation, and try to communicate. That is rarely successful, but at least it opens the lines of communication. The next thing you should consider is engaging a mediator, a neutral, who will sit down with both of you, first separately, then together, to talk about the issues, to see if you can come to some kind of a resolution. And hopefully you can write that resolution down on a piece of paper for your operation going forward. The sooner you start to talk about your problems, the better chance you have of them resolving. If you wait years and just let things simmer, your likelihood of success in a resolution context is, not nearly as good. Mediators are great. You need to pick, as Megan and Janelle will tell you, you need to pick a mediator who's got a familiarity with this kind of an issue, maybe who has done it before, who understands that it's not just a legal issue, but it's a highly emotional issue as well. And Janelle, there are other ways to go? Court might be next.
Yeah, so certainly court, if you have agreements, you might have an arbitration clause, or the parties might be able to agree to arbitrate. So let me just start with kind of mediation. And I agree with the order in which you've suggested. And I also agree with your excellent recommendation of not to take advice from your friends who want to tell you and they think that they know. So, but with mediation, here's the deal with that. It's not binding. So I would say that's the downside is you could walk out, you could spend a day mediating or maybe longer and you don't have a deal. That being said, if you get a deal, it's worth every penny of your time and of the mediator, paying the mediator, because the biggest benefit of mediation is you can pick somebody experienced that goes back and forth between you to try to help you resolve a very complex set of issues. And two, you get to choose. So you are controlling the outcome because nobody can make you agree to anything. Why is that important? Because it's your business. And you're going to have a much better outcome, even if you don't like it, even if you think it's not winning, it's still likely a much better outcome than you can ever expect to get in litigation or an arbitration, where you have a decision maker who's going to decide how to conclude your business. And they're never going to know the business like you know the business. And the business is never going to mean as much to that decision maker as it means to you. So having that control is the biggest benefit to mediation and trying to get it resolved early on. And people always say the best result is if neither side is happy at the end of the day. And what I can tell you is at the end of litigation of these disputes, neither side is happy because of the time and effort and energy. So you might as well just accept that early up front and go into the mediation knowing and understanding that and expecting that. Arbitration is a private matter. So if the parties either have an arbitration clause or can agree to arbitration, that is one of the benefits of arbitration, is you may be able to keep it private as opposed to if it's public litigation. And usually you get to pick the arbitrator. So the parties have to agree upon an arbitrator. That means you may be able to find somebody that's more experienced in your line of business or in the specific issues that are at issue. Maybe it's a valuation, somebody who has experience with business valuation, which could be important. And then, of course, litigation. And I would say with litigation, there are just some matters that need to be litigated. The parties are just never going to agree. And so the benefit of litigation is it is a resolution process and it will end. There'll be deadlines, there'll be rules that need to be followed, and you will have a decision at some point at the end of the day. With litigation, there's appeal rights. That can be good, that can be bad. There's very limited appeal rights with arbitration. So, but some people just need to be able to tell their story to a judge. And they are never going to get something resolved until they feel like a judge has heard their story. As again, we'll go back to what Judge Mulroy said at the very beginning of this presentation, which these are emotional matters. And so sometimes you just have to go to litigation, and when you do, it will get resolved. So that's what I would say is the benefit of that path.
Even though it seems like sometimes it'll never get resolved.
Yeah.
It does ultimately in litigation. Dickens wrote 200 years ago about a case that went on for so long that all the money that they were suing over was gone by the end of it. But sometimes you have no alternative. I totally agree with that.
Yep.
Yes, I one of the cases in which I was an expert on that point, tens of millions of dollars at issue. Both experts submitted reports, simultaneous exchange, 2 days before the scheduled arbitration hearing. The reports, despite the scale of the valuation at issue, we were only about $1.5 million apart. So you're talking about a tiny percent of difference. The parties insisted on proceeding with the arbitration hearing, the entire process, because it was a matter of principle. And so you were saying how contentious these business divorces can be. And they were sophisticated parties. There was actually a private equity fund in which one of the principals went out, and there was nothing in any of the agreements, despite how sophisticated they were, about how to address when one of the principals of the private equity fund wants to withdraw. And it ultimately was resolved, but it's just a sign of how contentious these can be, even with sophisticated parties. So with that, I'd like to open it up just for a moment here for closing comments. So Megan, Janelle, Judge Mulroy, are there any closing insights for maybe 30 seconds each you'd like to share with our audience?
Yeah, I guess
I don't have it.
Sorry, Judge Mulroy. I was going to follow up on what you were both speaking about, the arbitration and the court and the different options that you've got. And I wanted to say you've got to think of it from the perspective of how much damage you're doing to the business in the meantime as well, because every bit of this dispute is causing a disruption, and the disruption is hurting the value of the business, maybe temporarily, but hopefully, not permanently. The faster you can get it resolved, the less damage is going to be done.
Well, following up on that, that's a great insight. Following up on that, you don't want to turn your life into litigation. You want to go back to your business. That's where you were happiest. You want to get this resolved as soon as possible by any means possible. And the only way to do that is to curb your emotions, right? To put them to the side and let the expert, let the lawyer, let the valuation expert help you run this down, get this behind you, and get back to work.
Yeah, I agree with all those comments. And ultimately, at the end of the day, what you really want to do is make a business decision.
Yeah.
You can focus on making a business decision. And I tell a lot of my clients, some who are sophisticated, some who are not, that if you were in a negotiation with a customer right now over a large contract, you would view it as a business negotiation. If you can picture it that way, you will get this resolved. And that should be the goal. I absolutely agree with Megan about the comment about damaging the business in the interim. And again, it's in my interest for the litigation to go on forever. But I counsel my clients to try to get it resolved as quickly as possible, because that's in their best interest. And I strongly believe that.
Well, thank you, everyone. On behalf of Financial Poise, Judge Mulroy, Janelle Dressen, Megan Beckwire, we really appreciate your insights on behalf of our audience. Thank you very much. And to all of our viewers and listeners, Financial Poise really appreciates your joining us today live or on demand afterwards. And we look forward to finding opportunities to see you again on future Financial Poise webinars. Our website is financialpoise.com. And this concludes today's program. Take care, and we hope to see you again. Bye-bye.
Thanks, everyone.